Ian, thank you so much for having me here. This is really a momentous occasion for our organization, which brought this application. So the context behind the application is we as the Embrace Project actually discovered through the second applicant, who is a rape survivor, who reached out to us after we conducted a educational series on consent. She was the first person to point to us that there were these major flaws in the sexual offences legislation. She, in fact, opened our eyes to the fact that you could prove beyond a reasonable doubt as the prosecution that there was a lack of consent when committing some particular sexual act or sexual offence, but that the court could still acquit an accused person based on an inability to prove criminal intent by the prosecution. And the reason for that is because South African law applies a subjective test when it determines whether or not criminal intent existed. Now, for all criminal matters, you do have to prove intent. The absence of it means that there was no crime committed. But this is particularly problematic with sexual offences. And the reason for that is what the court does is it completely ignores all the factual and circumstantial evidence surrounding the incident of sexual violence. And it hones in specifically on the subjective state of mind of the accused. And what that means in practice is that an accused person, if they have particularly perverse views around consent or sex, for example, there is a higher likelihood that in their case, they would be acquitted because they subjectively wouldn't have understood, for example, silence or a lack of resistance to mean that there was no consent. So the effect, again, of having this subjective test, which is applied when determining whether or not there was criminal intent, is that if there was no outward resistance by a victim, it was practically impossible for the prosecution to rebut a contention from the accused person that they understood the complainant to be consenting.
All right.
And what the amici in our case, so the Centre for Human Rights and the Psychological Society, the evidence that they brought in was so important because what they did was they showed the court that about 70% of victims of sexual assault actually freeze in the moment of the assault. They don't resist. They don't fight back. That is not the common reaction. And so we approached the court really to get in line with the behavior of society, the behavior of victims. And thankfully, the Pretoria High Court agreed with us. The court agreed that this current approach that we use when determining criminal intent for sexual offences is unconstitutional. And by implication, certain provisions in the Sexual Offences Act are therefore also unconstitutional, specifically the provisions that contain consent as an element.
So let's talk about...
In addition to this...
I'm sorry to interject there. I thought you had concluded your thought. So let's then talk about that section regarding consent. If that has now been declared unconstitutional, do we have any knowledge right now as to what the text might read or what the recommended text should be?
We do, because we recommended the text that is now being read in. So what we wanted to do, and obviously in addition to this declaration of unconstitutionality, you can't just have this lacuna, this gap in the law. We asked the court to place a positive obligation on accused persons going forward to take steps in order to ascertain whether or not consent is given. So for the first time in our legal history, in terms of sexual offences, an accused person can no longer rely on an assumption of consent being given. They now have a legal duty, an obligation that has now been placed by the court to take what the court calls, and what we ask that it include, objectively reasonable steps to ascertain consent. And yeah, that is a game changer.
Wow. We know, Leanne, that the Department of Justice opposed this. Do you anticipate that they will likely appeal? And if they do, is it your foresight that this might well land up at the Constitutional Court?
So I think I'm going to answer your questions in two parts. The first is I did not anticipate that the Minister of Justice would have opposed this application to begin with. So I don't know what to anticipate with regards to appealing this judgment. My hope is that they will not. And with regards to the Constitutional Court, the law requires that any declaration of invalidity, constitutional invalidity, has to be confirmed by the Constitutional Court. So it can never stop at the High Court. We are now in the process of submitting an application to the Constitutional Court to confirm this order by the High Court. And we're hoping that the Minister of Justice will just go along and abide by the court's ruling. And if it wants to participate in the proceedings, you know, perhaps it would do so in terms of suggesting an alternative remedy if it has one in mind. But I genuinely hope they don't oppose this or appeal this judgment.
Yeah. In closing, just out of interest, based on exactly your opening of this final question that you've just responded to, you're saying that you did not anticipate that the Minister of Justice would even oppose this matter. So just out of curiosity then, what were their arguments in court, if you're able to just sum that up for us?
So I think the crux of their argument, they had a few, but the crux of their argument was that what we were asking for, this positive obligation and this changing of the test from a subjective test to an objective test, it would reverse the onus of proof from the state having to prove beyond a reasonable doubt that the accused person is guilty to the accused person having to prove their innocence. And at the hearing and in the judgment, the judge dismissed that argument out of hand. He just did not find that to be a plausible argument at all, because that is not what happens. That is not what this remedy does or what this order will do. It does not reverse the onus.
Very interesting indeed, and quite a positive development for our laws, particularly the Sexual Offences Act. Thank you very much for your time. Leanne Germanos Manuel is with the Embrace Project, and they have won in court. It now has got to move to the Constitutional Court for confirmation, given that this does invalidate sections of this Sexual Offences Act.